Okay. Yes, section 67(2), if you see,
Yeah.
the proper officer not below the rank of the joint commissioner has the power to authorize search, and he can authorize, the junior officers of the central tax to carry out the search and seizure. Now, take the example what happened when they come for the search and what power they carry under the law. As per the law, they have to carry the mandate of the joint commissioner. Now, the two questions we must raise to ourselves. First, who is the proper officer? Because we have to read section 70 along with the section 67. There cannot be a situation for when the two sections are being executed jointly, the proper officer in one section he and the other section he. To my mind, that there is no possibility of that, because both the section 70 use the word the proper officer, and section 67 too also use the word the proper officer. Section 67 too has specified the proper officer should not below the rank of the joint commissioner. Therefore, to my mind, section 70 only could be executed in such a scenario by the joint commissioner, not by any other officers. Therefore, if we do not read that, then there is a canon judgment, if you remember, that would be here only, canon judgment. In that judgment, what happened? The Supreme Court said the proper officer means that particular officer only. It cannot be treated as any or every officers. Therefore, this distinction has been made as compared to the earlier provision. If you read the section, third slide, maybe section 14 of the Central Excise Act, there the power to summon was with the any central excise officer. Now, any has changed to the proper officers. Therefore, this distinction we have to keep in mind. Here, in practically, you will see the same, the investigations, summons are being issued even by the different officers. I have almost every cases. First day the summon he will issue. Next month he will issue the summon. Third month he will issue the summon. There is no possibility. That is the legal challenge you can make. Therefore, once you file the reply to the summon, you have to take this point. The second thing is that if this is the proper officer. Now, what was the mandate by the joint commissioner to the superintendent or to the inspector to carry out the search and seizures? Therefore, can we assume that that officer himself become the inquiry officers? Because whenever the summon you will read, they said, I am so and so making an inquiry against such and such company. So that means he assumed the role of an inquiry officer while he is on the search. At the same, that is called the on the spot, he is issuing summons. Now the question should be raised that whether he has a power to issue summon on the spot to anybody. To my answer to this question, yes, he has no power, because he is carrying out the mandate of his senior officer, and that mandate was very limited to go to carry out search and then seize. Whether that can be done or not, that we will deal with later on. But whether he has a power to issue summon, to my mind, he has no power to issue summon, because that power is not there. And if you want to further support your view, you read section 132(4) of the Income Tax Act, which was amended later on, because that is also power of search under the Income Tax Act. There was no power to on the spot to record a statement. That's why the parliament thought it. If we have to empower our officers, those who are the search party, once they want to record a statement on oath, they have the power. That means the parliament has given specific power under the Income Tax Act to those officers who are carrying out the search. On the spot, they can record a statement on oath. That power has not been conferred under the GST law. Therefore, you cannot assume that power is there. If that assumption is there, then there was no need for the parliament to amend the law under income tax law and to give that power. These issues you will not find answer. If you want some judgment should be given, judgment it will take time to come. But the question is that are we taking this kind of contention in our submission or not? If you are not taking, then how the judgment will come? You will take this submission, that it will be contested and it will be rejected by the officer, then you will take at higher pedestal and then you will find it. Here at this moment of time, we should only consider that whether that power of the summoning can be abused in such a manner that he assumed that he has a power or not. Therefore, we should answer to those questions first. The third thing is that when the summoning power can be exercised. If you read section 70, very interesting, which I had taken this first before, the Calcutta High Court, and the judge, who later became the Chief Justice in here in Bombay High Court, now transferred to the Justice. And he appreciated, that my contention. If you read section 70, section 70 says the summon can be issued in an inquiry. This word, if you see the highlighted in the red color, that means whether someone can be an instrument to conduct an inquiry, or whether section 70 empowered the officer to conduct an inquiry, or whether section 70 only a procedural provisions. The power of inquiry must be some other provisions, because this provision clearly says if you want to issue a summon in an inquiry, that means inquiry must exist on the date when you issue the summons. But generally what happened, in so many cases when there is, nothing happened, at very first instance, he issued a summon to the assessee by stating that I am so and so making an inquiry against your company, or without even naming the company, under GST inquiry. Very so bold. Whether he can do so, my answer would be no, he cannot do so. And we should appreciate this contention that we should not challenge it like that. It is happening. That means there must be law. We are living in a different kind of words. We are not living in European words where everything is, done systematically. If the officer has the power to accuse everybody, even the professionals, that no, they are connivance and they are evading taxes. Why you presume that the officers are honest? Every next day or the second day, CBI arresting GST officers as well. Therefore, we should appreciate the inquiry must exist prior to issuance of summon. Because if any criminal jurisprudence or any civil jurisprudence, you will ask any advocates, summon can never be issued at first instance. Summon only can be issued once there is a complaint, once there is a plaint, when it is admitted by the court. Then you ask to the court if you want to, ask someone to come as a witness. And next point is also what he can ask in the summons. If suppose all other things you accept it, the summon, generally what they are asking. If you see the one slide, they are asking, so many things. Even today, one of my clients has sent, the one letter, not objective summons. He said, you give me the n number of records, including your all kind of returns, like 3B returns, 2A, he will ask bank statement. He will ask, give me the information rather than a documents. The law says, if you read section 70, because nobody can go beyond, he has the two powers. First power is that to seek a document. The second power is that to, evidence. Evidence means to record a statement. Generally, if you see the summons, they will say to give a statement, and second, documents. And documents may generally you say as per annexures. If you read the annexures, it says provide me the information. There's a monthly information, yearly information, this information, reconciliation. That means essentially he's not asking any documents. He's asking you to create a document. If you will see my old judgment of ebis.com, where the same question I raised, and you will find a judgment also in this slide. The ebis.com, the same question I raised before the court, and court appreciated, delivered the judgment in our favor. I said the law says that he can ask me document, but the law does not permit. He can ask me to create a documents. Because if asking me something, I have to create a reconciliation or a particular format or the particular detail I have to furnish. Document means it must pre-exist. It should be in my possession. It should be my documents. Then only he can ask. If these things are not there, then how he can ask me? Because the law otherwise should be changed. He can ask anything under that. Why he is writing a documents? You can't change the parliamentary language. And the judge asked the other side, can you show us any provision where you can direct him to create a document? They said there is no provision in the law. But for convenience sake, we are asking. They said reject it. There is no convenience sake or inconvenience. Question is that what law provides. Therefore, the first question is that if he is asking anything which is not in your possession, not your document, is asking to create a document, you must reject it by making a written reply to that. The second thing is that a document which is not your document can he ask, like he is asking 2A. And I asked some of my friends from Chartered Account community, because what is 2A? They said it is auto-populated documents generated on the GST portal. That means it is not my baby. You are asking somebody else baby, I have to give it. So it is a baby produced by the government of India. So he should ask government of India to give it. Why I should give? And how you can sign that 2A? It is not created by you, not generated by you, and it is also not stagnant. It also gets changed also. That means you are signing something, which is not your documents. You simply reply, this is not the documents, my document. This is the auto-populated. Whoever generated, you ask from them. So once you will ask, and he may have no power to ask from that. That is his outlook. That I can't give him the power. Therefore, that also we should keep in mind. The next question is that once a statement is being recorded, you will see invariably in every cases, which because of the lack of knowledge, maybe by the professionals, maybe by giving the confidence on that, we cannot ask those documents, those questions, which is not a statement of fact. Like you can ask a statement of facts to be recorded, which is relevant to the proceeding. You also read section 70, it said anything which is relevant to the proceeding, which is not relevant, he can ask. Generally, he will say, what is your MD name? Give him mobile number, give his email address. Why is asking? He has to first, because law says when he consider necessary to issue a summons. There are n number of judgment. I will not go in detail because of the paucity of the time. When he consider necessary, then only he can issue a summons. Not because of that he has a power to issue summons, he can issue a summons. He must make sure on the paper and he write in his notebook. If he in fact read with the CBIC instruction, they said you have to take the permission from your senior officer also. Therefore, while recording the statement, if he is asking certain question, which is a pure question of law, you simply deny to give answer to those questions. By recording that, it is a pure legal question. It will be answered by my legal counsel, chartered accountant, and that too at the appropriate proceedings. These are the, because you must appreciate, once the summons are being issued, even if it is legally valid, what is making, he is making an inquiry. Inquiry is regarding the fact-finding authority. Inquiry is not a decision-making authority. Therefore, he has no power to ask any such legal questions. And in fact, if you read, he has no power even to adjudicate those questions. CBIC circular said a superintendent power is limited to 10 lakhs. When he is making an inquiry, he said there is a evasion of 100 crores. If assuming that 100 crore evasion is there, so where is his power? His power is only for 10 lakhs. So how he is making an inquiry even? Then we can correlate this. And secondly, the question of law is making, why you will answer. The two judgments, one can, I remember the Calcutta Discount Company, if the constitution when judgment of the Income Tax Act, 50s, the judgment of 50s, very old judgment, where the majority decision of that judgment is very clear. They said, don't expect from the assessee to assist you for interpretation of the law or inference, what inference you will draw from the documents. His job is limited to provide you the documents. Whatever inference you want to draw from your document, it is your wisdom. Don't ask the assessee to assist you to understand. Or similarly, if you are suppose the officer is asking you to give me the copy of the agreement, you can give the copy of the agreement, but he cannot ask you what is the meaning of this clause, whether under this clause you are entitled for the exemptions or not, whether you are liable to pay tax or not. That you are not supposed to answer, that they are not supposed to ask any such question. One more thing we should appreciate. Suppose in summons comes, generally he will write, this is a offense under IPC, etc. What it can be done. We should not afraid about it. Like first summons has come, you don't go there. No, heaven will fall. Let me tell you, nothing will happen. He will issue second summons, third summons, because in fact, he is issuing summons with a malified intention. That's why I'm saying so. You read the CBIC circular of 2007, 2015, and then 2022. All are saying that in the summons they are, creating instinct, fear in the minds of the assessee, using certain kind of languages which they are not supposed to use it. In fact, in some of the summons which we are challenging Delhi High Court, ultimately withdrawn by the officers in the court, They said, you will not move from the office without my permission. That kind of language can never be used. Delhi High Court came down heavily. And in fact, now you can read the CBIC circular where the summon format has been prescribed. And summon format does not, use such kind of language. So you should not afraid about it. Therefore, suppose you don't go in the summon repeatedly, then they have the power to make a complaint to the concerned magistrate. Then a further proceeding of the criminal proceeding can be initiated why you did not obey the order of the public servant which you are supposed to obey. Therefore, if a summons comes, you must file a reply taking these all objections. You are asking not the documents, you are asking the details to create the documents which you have no power. If it's .com judgment, you may quote it or don't quote it. Then you are not the proper officer because here the search was authorized by so and so. He is the proper officer. You are not the proper officer. Third, your mandate was only to go a search and seize. Mandate was not to conduct an inquiry which you have assumed yourself. Fourth, you have no pecuniary jurisdiction. Allegation is in crores and this officer as per CBIC circular this. Then he will go to even the magistrate. Magistrate will appreciate because here the officer himself will say, no, how you are saying like this and that. Like recently, one of my company from Bombay is being investigated by Delhi officers. They said, why you have written? My client has written as per my discussion that you have no jurisdiction. Why you have written? You prove that you have no jurisdiction. We have written. Now you decide whether you have a jurisdiction or not. What proof? You give me a so-cause notice, then only it will be adjudicated. It is not like that you verbal, discourse can be, have with that. So therefore, we should be very, very particular about it, what power he has. Now let's come back to the section 67(2) also. That is very interesting. Like one of the interpretation has come in the CA Arvind Goel decision also. Now, what can be taken and what stays? Every provision you challenge, then something comes. Now, taking away the cash has become a common thing in the search. Whether it can be taken or not, that we will discuss. Secondly, who has the power to make such kind of things? And third, how the seizure can be conducted. Merely INS 02 is enough or not. So read these 4 lines very carefully. He says the proper officer not below the joint commissioner, and he has to form an opinion. He has to form an opinion whether the goods is liable to be confiscated. That means who has to form an opinion? Only the joint commissioner, not that officer to whom the power for the search has been given. The second thing is that for the documents or any other things, records, documents, and the 3 words are used.
Section 70.
As 67(2). Yes, documents, books, or the things which in his opinion means who is his? His is the joint commissioner, not below the rank of the joint commissioner. He may be the higher officer, but not below the rank of the. Therefore, first he should have all these things, some material before him, and he should form his opinion. Then he can authorize any other central tax officer to carry out the search and seize these goods, documents, books, or things. Therefore, if you see any such proceedings, invariably the such proceedings are being carried out by the superintendent or the inspector, the senior intelligence officer who is the equal rank of the superintendent. And in INS 02, they will write, I believe. He write, I believe this goods is liable to be confiscated. In fact, most of the cases it is a pre-printed form. And that pre-printed form is wrong. In fact, that uses the word section 67(1)/67(2). 67(1) does not give any kind of power for the seizure at all. 67(1) is only for the purpose of inspection. In fact, 67(2) you read it, it says search can be authorized either because of the certain incrimination things as found during the inspection or otherwise. Therefore, inspection, those who are carrying out under section 67(1), and if they found something, they have to again inform to the joint commissioner, and then joint commissioner has to form a second opinion, second reason to believe, and then he can authorize the search. Therefore, to my opinion, if you read the INS 02 carefully, INS 02 invariably will say that officer who is signing it, I have formed an opinion that to my mind the law does not permit, that officer has to form an opinion. Opinion has to form. Now the question arises, the court may ask, Mr. Mittal, once the search was authorized, how he can know in advance if some material will be found there and that is liable to be confiscated? That is not my outlook. What the language of the law is drafted like this. The parliament has all power to redraft that, because this provision is very clear who has to form an opinion. This does not say the officer to whom he has authorized for search and seizure, he can form his own opinion. That means the opinion must be formed in advance only. And that advance opinion only can be formed by the joint commissioner, not below the rank of that officer. Now the question arises about the case can be seized or not. You must be knowing that there is an adverse decision, final judgments from the MP High Court about 1.5 years before or 2 years before, that case can be seized. And that is on the basis of the interpretation that the word things has been written here. So therefore the case will fall under the item things. To my opinion, that judgment is not correct. And that's why the C.A. Arvind Goyal case, opinion has been, given by the Delhi High Court while returning the case of the chartered accountant. In that case, the chartered accountant house was searched by the GST officers, and they took over the case, whatever case was there, and that we challenge that case seizure is illegal and entire proceeding is illegal. That has to be returned, which ultimately now returned with interest. Now the question arises why the case cannot be seized. If you see, there are 3 words are there. First, the goods can be confiscated. When goods is liable to be confiscated, only then it can be seized. Now, whether the case fall in the definition of goods or not, if you read section 2, clause 52, it clearly says the case is excluded from the definition of the goods. Therefore, if it is excluded, that means it was included in the definition of the goods. Had it not been included, then there was no need to exclude it. And that if you read the very old judgment of the Supreme Court in Sunrise Lottery case, in Sunrise Lottery case, a similar question arises, whether the actionable claim is the goods or not. This, the Supreme Court said, actionable claim is goods, but for exclusion from the definition of the goods. Had there not be actionable claim included in the goods, there was no need for the parliament to exclude it from the definition of goods. Therefore, the case fall within the definition of goods. The parliament thought it fit to exclude it. Therefore, it has been excluded. Now, the second question arises whether it can fall under any other item mentioned here, documents, records, things. My interpretation is that, which is accepted by the High Court also, while forming the prima facie opinion even, that in the same line, various words have been used. If something has been excluded by the parliament from one word, can you assume it automatically fall in the second words? To my mind, it is not possible in the law. Otherwise, it goes very basic ethics of the interpretation of any law. Second thing is that of course, the case cannot fall within the definition of the books or the documents. Now falls as things. Let's assume for a moment, for argument's sake only, the MP High Court judgment is correct. The case fall under the things. Then we should appreciate, even if it is a things, what are the provisions are there? If you read the second proviso to the section 67(2), it says anything which is seized, like the things, books or documents, not about goods, then it has to be kept by the officer for his examination, so long as it is necessary for examination. That means it has to be kept in as it is position. It cannot be handed over to the bank or somebody else, to keep it in somewhere else. Whenever they seize the cash, they take it to the State Bank of India, deposit it in the name of the President of India. That means you don't require it for any examination. Because the law says the books, records, or the things, if you seized it, you keep it in your possession so long as it is required for examination. As soon as you part it, that means you don't require. That means you have to return it immediately. Therefore, these arguments has not taken, both arguments about it is excluded for sunrise judgments or the things, the second provision, these were not taken into account by MP High Court, and Why? Because these were never argued. Once, whatever argument you take, the judgment generally come on the basis that unless it come in the mind of the bench also, yes, there are certain other things which they make research, etc. Some other interpretation comes. So Delhi High Court has the firm view that even if it would have been a things, then you keep it as it is. You can't touch it. Because like I have not argued that, but I have another example in my mind. Like suppose a bribe case happens. When the money is recovered by the CBI, he took some bribe. Then that bribe become like a case property. It has to be kept in a sealed envelope, has to be produced in the court because it is a material piece of evidence. But if that money, if the CBI will deposit it in the bank, then you lose the evidence and then there is no case can ever be proved against that person. Therefore, there is no need to case it. And in this, to seize the case, in this case, another things happened very interestingly. They said we are writing time and again to the income tax department. But income tax department is not eager to take any action. They are not responding to us. Even in very first hearing, the judge asked them why you are keeping the case. You return it. It is the duty of the income tax department to take action or not. Like suppose I am carrying a case in airport. Let's say I have the 100 crore rupees cash in my suitcase, and CSF, found it. So they themselves will not do anything. They will inform to the income tax department. They will come and they will take action. Therefore, it is the GST law. It is not the law of universe that you can do anything under the earth and every action you can take it. That is not possible. Therefore, if such kind of arguments we analyze it, we must take it. And then if they will go to the court in any case, they have to answer to those questions also. And in this case, in fact, that particular, the chartered accountant was misled by the officers. He visited department at least 12 times, which is on records, the letter he has submitted. Every time they were asking so many explanations from this case has come like this and that. And to my mind, he has wrongfully answered to those questions because they were not supposed to ask those questions. And he has, rather the case was quite become tough also because if you answer in different persons, then many other questions may arise also. So in my opinion, they have no power to seize the case. Now the another question also come. Sometime INS 01, where they have the power of seeking some kind of authorization. If you want to have it, they don't give it. Now the questions are being asked. Can you take that copy of that? Answer is no, because they will not give it. They will give it when the final case is made out. But the question is that still can you have it? Yes, answer is that you can have it. If you read the law carefully, if you see at the bottom of this slide, subsection 10 of the section 67, it clearly says, the certain power which was given, to the magistrate, the words they have substituted because the provision of the consent provision of the CRPC is applicable, and instead of a magistrate, that they have substituted the word the commissioner. Now, if you read the section 165 of the CRPC, that empowered you to seek those reasons. I'm sure it would have been quoted somewhere. If one judgment, also you can find it at the Allahabad High Court. Section 165 says the police can carry out the search only of those circumstances where they believe otherwise those things cannot be recovered. If things can be recovered without carrying out the search, you cannot resort the power of the search. That also you should appreciate. Because one thing we should appreciate under the Income Tax Act, if you read section 132, it is a very, very long section. There are so many provisions or subsection. Here the section of search is very small. Section 67, 2 essentially is the power, rest are the many other things, written documents and etc. of the goods. Therefore, we see the only limited circumstances where the power has been given. Like the document, if it is secreted, only then he can carry out the search. But what happened? Usual course of the documents which you are maintaining, they take it away. If you read there, one of the circular of February 2021, the CBIC said we have received many complaints, as well as CVC also has received many complaints, Central Vigilance Commission, that when the search are being carried out by the GST officer, they don't adhere to the law. And it is illegally, sometimes they are carrying out and they read. That means the board has information that the search are being carried out without adhering to the law. But they failed to take any action. Rather, they said the whatever manual we issued in 2004 under the DGCI, that is still applicable. I am giving the recent example when the search was carried out. A Panchanama was drawn, and in Panchanama it is written that we find on verification there is a difference in the strokes, and the assessors agreed about this difference, saying he agreed to pay the tomorrow that amount, and in fact he has paid next day that amount. Once case came to me, I interrogated that assessee whether any verification took place, because why I have interrogated, because in Panchanama nothing is mentioned except an amount. I thought in my mind, how this amount is right. If there is a difference, you will write books of accounts, this stroke was there. Physical verification, this stroke was there. As a chartered accountant, all we know, we have carried out the stroke verification, and then we will write that is the difference. Then we will quantify it. This is value. Then only this figure. No such document was there. Then again I verified whether they have asked you to sign some document. Nothing. Then first we send a notice to those officers, and next day we filed the writ petition. And we made a request. All original reports should be called to the court, and court agreed, and they are called now. Thereafter, they are not issuing any summons, which they issued in 10 days, 5, 6 summons. Now they are not issuing any summons at all, because they know it is a fake thing. Therefore, what I am appreciating, you must appreciate what I have appreciated in large number of cases. Most of the cases, 99% cases, every such case you will find, something wrong with the department. Like one of the case I'm handling, a search party from Ahmedabad DGCI came to Mumbai on 6th January 2021, and search was carried out here in Mumbai. And everything happened. That party approaches to me at later stage after submitting large number of documents, going with their chartered accountant so many times in Mumbai to Ahmedabad. Then I examined those documents. You won't imagine, there are 3 documents they created on that day. First is the Panchanama. The second is the seizure memo, INS-02, and the third is the summon they issue on the spot. And I find in all the 3 documents, name of the officer is same, but the signature is totally different in all the 3 documents. Stamp is there, one stamp is of Mumbai, one is in Ahmedabad stamps. If you should imagine whether the same very officer can have a different signature. I'm not saying that different means slightly different. It is altogether different person. It is not like slightly, And the second thing is that can you have a different designation? Can you have a different stamp? The first thing is came in my mind. It is like a special 26 picture. I do not know whether they were genuine officer or he is totally floored by those officers. Therefore, as a professional, it is also your duty to examine from those angles also. Second thing, once they have the INS-02, like in one chartered accountant case I am handling in Faridabad, they came for the search. They took away the mobile phone, then the laptop and diaries and so many other documents. Whatever they get, they take it away without knowing the authenticity, whether they have power or not. Then again, I interrogate the chartered accountant. How they took it away, whether any seizure memo, or they said nothing. So we filed a writ petition in the court. And very first argument I took it. But kindly read Rule 139. 139 says, if you seize, then you have to have a seizure memo. And seizure memo, you also have a form and opinion, goods were liable to be confiscated. These 2 conditions are mandatory. I'm not on a point whether he can do it or he can do it, whether joint commissioner, lower officer, that is the second point. But they have not done it. Therefore, it is like a dacoity, they have taken it away. Once my argument, then judge asked the other side. And government advocate was very fair. He said, yes, we have not seized it. We have just taken it away. Just said, we have not heard this kind of things. We have just taken it away. Like, you can do anything, whatever you want. Because my argument can go to some extent that today you are taking away my laptop. That means evidentiary value you are compromising. Then you can manipulate the entire data today. Certain important things you can delete, certain other things you can insert. Though maybe technically you may find out when it was created, when it was done. Yes, sir.
Sorry, sir, to interrupt. Actually, it happens. What happens is if they ask you to pay something, then they themselves take the login password, get into it, compulsorily make you pay by way of DRC-03. Even it is a legal issue. On that legal issue, they will make you pay the day. pay by way of DRC03. And it will appear, if you go to the logbook, it will happen that from the same premises, the login has happened, okay, and they are the ones who file the DRC03.
In fact, we all these things should take on recourse. We should not keep it. The facts, as soon as come to your knowledge, you should record it and you should make a complaint to their senior officer. This happens. That can benefit you. And in fact, in the last week, 2-3 such cases have come to me. They said they have changed my login password. They themselves has filed my, fake return from my laptop, nil return, this 3B return. Whereas my GSTR 1 return showing crores of rupees sale, but GSTR 3B is 0. How it can happen? And second thing, they said they have reversed my 0 because so that my credit goes to my electronic credit ledger. From they have made the payment in DRC03 also. I said you must make a complaint about it. Otherwise, like if your car is stolen and you feel like that it is a 15-year-old car, battery has taken away, it has become dumb. But suppose a rape happened in that car or a terrorist, attack happened, then you will be in serious trouble. Your car is your car. You must register a complaint. So supposing from your laptop something transaction has been done, it is assumed to be you have done the transaction. In one of that client, he said my CCTV was on and they were not knowing how to close it. And this entire CCTV has recorded that he is manipulating the data for 2 hours. I said that CCTV you must preserve and we will make the life hell of that officer. That I can make sure. You forget about what wrong things you have done or correct things. Because wrong or correct, he will first handle his own case. And nothing is wrong. One thing must appreciate in GST, everything is digital now. Suppose your client has filed 100 crore rupees return. By no means you can even deduct of 1 rupees. The 100 crore rupees remain 100 crore rupees. Then you have to file only on the legal grounds. You can never change anything now. That is not possible. Therefore, you have to take a legal ground. In the past, might have happened. The officer may take the money. He may remove those documents, those data. Here it is not possible at all. In fact, I was told, now the government of India is asking to the income tax department during the search, if you get anything, you must scan it immediately. You must make a soft copy of those documents. Therefore, it is a mandatory recourse now. Therefore, these things we should appreciate. Now, one more thing, how they take it away, if merely seizure memo is enough, to my mind, it is not enough. Along with that, they have to seal those documents and those things also, like laptop mobile. If they are not sealing it, to my mind, it is illegal, because as well as the section 100 of the CRPC is also applicable. First thing, they have their own, the punch charge, which is illegal. Punch has to be independent. You read the DGCI manual. DGCI manual said how the stock verification will be done. They said which should be the punch. The Panchanama, Panchanama authenticity is also very important. So everything is very important in the law. That officer, don't argue with that officer. Officer has no power to do it. He has been taught by hook and crooks you get money. They work like that. But the officer is, not doing the things as per the law. There are n number of judgments that will show if the law prescribes certain things has to be done in a particular manner, it has to be done in that manner only. Otherwise, it is illegal. Therefore, if that has not been seized, like in one of my case, what happened, the DGCI intelligence, people carried out a search in Jaipur. And while carrying out the search, they took away all registered property deed, original deed with them. But the Panchanama, when they drawn it, in Savaria Sweets case, it would have been referred here. And in Panchanama, they said photocopies. And the officer also signed it, company officer. Now the company MD, who was already arrested, after release, he came to me. He said, can I get the original sale deed? I said, yes, you can get, but you have to go to the court. But he said, the problem is that in Panchanama, my officer has signed the list of the documents which they have taken away, the photocopy. I said, that is, you leave it. Because if somebody on a gunpoint asks you to write something, that does not become a valid thing. It has to be examined. Then ultimately filed the case. I myself told to the judge, I said, look at this Panchanama and the annexure with the Panchanama, it is written photocopy. But these are original. He said, how you can say original once your officer has signed it? I said, very simply, I said, this is made of a gold. But they write it is not made of a gold, it is a plastic. So you must ask to bring those things before you, and they will open the seal. If it proved to be a plastic, you send me the jail. But it is proved to be gold, then you send those officers to the jail. But it has to be sealed. Otherwise, the officer become greedy. The gold, he will take it as home, and in place of that, he will put the plastic. How you will ensure it? My books of accounts says my stock is correct, but you have not sealed it. Tomorrow, his books of accounts you place. How you will verify? Therefore, it has to be sealed. He appreciated. The next day, the officer filed an affidavit. We took original, but we by mistake written photocopy. And all the documents they returned, which you could not have think in your dreams. The people advise my client to pay that money, this, that, and they will. As soon as you will start paying money now, your case will spoil, and they will hunt you for like anything. So ultimately, you get all those documents also. So it is the important things like the chartered accountants. They took away my diary. Forget about diary. Diary it's a long back. Supreme Court said the diary has no evidence value. You have to. I write like I have written so many things. You ask me to give I have written. Would it be an evidence? Once the clients comes, I write, okay, 500 crores, I will write 500 crores. And somebody will say, no, Mr. Mittal has taken a 500 crore rupees bribe. It is not like that. Once as a professionals, you work, these are your working papers. You discuss, many things you write, these have no evidence value at all. So whenever they create a fears, if you start, creating fear in your mind, psycho fear, then you are in trouble. And don't afraid about it. One of my clients said, every time he comes and he take away the money, right? He said, otherwise I will report it to the ED. I said, next time he comes, you said you report it to the ED. I am also reporting it to the Mr. J.K. Mittal. He will also report to the ED. He will return your entire money because he is also in loose end. Because he take away the bribe and he is not afraid. And whatever you have done, my every client said, I have filed the return. I made the payment for all these things, whatever bills you say, whatever, transaction is saying, it is reflecting in two way, it is matching everything, but he says it is a fake. So then it's a fake in his mind. Somebody asks you prove, she's your wife. How you will prove it? She's my wife, that only you can say. There is no, affidavit is given by the government of India, a particular person is my wife or my husband. That, it is only the people can say, yes, they are living together. But that does not mean they are living together means they may be the live-in relationship. Therefore, the something, you have to cast the burden on the others, those who have alleged. Therefore, if you see one circular, the fake invoice also, let me give, yes, this 171, the fake invoices. One line I will just read it for you. I think it is in C. B. Just and then B. Yes, you read this, very interesting. If you read it, you will never heard that how the CBIC, issue a clarification. You read the 3 lines very carefully. A has issued the invoice, tax invoice to another person, registered person B, without any underlying supply of goods or services, and B have taken a credit. But thereafter you read, B further issue invoice along with the underlying supply. They are the only person in this earth, they believe, I have taken an invoice without goods, but I have given them invoice with goods. Without purchasing, there could be a sale. That this circular is saying. If you read the judgment at the bottom of Delhi High Court under the income tax law, that would help you in large number of cases. You read very carefully, para 15.4, I believe, 15.9. Say the revenue chooses to disallow the bogus purchase. It would necessarily have to, in our view, ignore the corresponding sale recording against the same very parties. If you are making an allegation of the bogus purchase, there has to bogus sales also. So the sale is correct, purchase is bogus. The High Court said we cannot accept this argument. What is happening after this circular now? They will say A is liable for penalty. B rather. A says we will not recover the tax because there was no supply. A may liable to penalty and B have to reverse the input tax credit. But the C will take input tax credit because they said it was an underlying supply. Now there is a multiple, things you can argue it at any place, but don't argue with the superintendent. One mistake we always make, when the superintendent is making an inquiry, how we can open all our argument before him, because neither he has a power to decide any issue. His power monetary limit is only 10 lakhs. IGST is 20 lakhs. His allegation of crores, not of 2 lakhs, 3 lakhs, because 2 lakhs, 3 lakhs, no such will fight. He will pay the money. So then why we should argue with him and why we should open it? Now they are making multiple cases. A case they will make in Bhiwandi, B case they will make in Delhi, C case they will make in maybe Allahabad. Is it possible in the law? You have to combine all these cases at one place, then only it can be decided. They will never produce your 2A return, 3B return, etc. They make all false allegations. There is an evasion of tax, there is a fake invoice, they have taken this credit, that credit. That ultimately will be decided in your favor ultimately. If you read such kind of circular, they have no authenticity in the law at all. Now, one more issue I want to take up, with you. Very interesting issue. If you can remember, Section 50 was amended, charging of interest. And that time also I had a reservation. It was no need to make an amendment. If the Section 50 clearly says you are liable to pay interest if you are making a delaying payment of tax either wholly or partially. That means the law permits you to make a part payment of tax. But they were saying, you pay the tax, if delay in filing of return, you pay the interest even on the input tax credit, which was ultimately rectified through the legislative amendment with retrospective effect. That time also flagged another issue. What about the cash payment you are making? Tomorrow they will say the cash payment is also liable to pay interest, and now it is happening. Few professionals approaches to me, they said, so-called notice has come. You have made the cash payment through electronic cash ledger, but since your return was delayed, whatever amount you deposited in the electronic cash ledger under Section 50, you have to pay the interest on that. Now, the one judgment has come from Jharkhand High Court supporting the department view. Yes, you are liable to pay interest on that cash amount, because under Section 49, the amount has been written, not the tax. So whatever amount you are paying in the electronic cash ledger is the amount, not the tax. That interpretation, to my mind, is not correct in the law. Why I am supporting the GST Council view? You read this 31st GST Council meeting, which was held in 2018. What it says, if you read only the yellow color, thus, although the law permit part payment of tax, but no such facilities has been yet made available on the common portal. Common portal means GST portal. Therefore, they are admitting, if you read the entire this is the quote, this is not my view at all. The GST Council said, as per the legal provision, you can make the part payment of tax and you can file the return also. It may be a defective return. But this facility is not available on the GST portal. So you imagine a situation that if I have today the liability of 1 crore rupees, but today only I have 90 lakhs, 50 lakhs, and I paid in the electronic cash ledger. I was expecting tomorrow is the last date, I may get more cash, but I did not get it. And my return is delayed by, let's say, 1 month. So those 50 lakhs I have deposited, should I pay interest on that? It will be the mockery of the law, because you understand why the GST law, if you ask anyone to make a statement, GST law is nothing but the amalgamation of the whatever the existing law was there. The existing law, did you pay any kind of interest on the cash payment you are making? Answer would be no. That means the GST law has created many portals deliberately by the officers while drafting the law to create a newer kind of litigation which no professional will think in their wild imagination even. I think income tax department will also take a clue from that. Whatever advance tax you are paying, you will change the word tax, the amount deposited. And on advance tax also, you will pay the interest. So nobody will pay. When I have to pay the interest, then better to keep it somewhere else. At least something I will get. Therefore, and it will lead to the disaster situation. Because what the law says, what the very important, you read Section 132. Section 132 says, there is a punishment, there is an offense. If you collect the tax for 3 months and don't deposit, now what happened? Suppose I don't want to file the return because of the XYZ reason, because there are so many reconciliations, so many things happen in a company. But whatever tax you have collected, you deposit. Where you will deposit? In the electronic cash ledger. And as per interpretation of this law, you collect it, but you don't deposit it, because this is the amount, not the tax. That means you will be behind the bar. There is no other mechanism under the law. Read section 122 also for liable for penalty. Therefore, we have to see the consequence of that. The consequence is very severe. Sometime what happened, I was just discussing before this conference, then whenever case come as a professional, we have to have a different facet, which comes, how to convince a judge. If you convince a judge, let me quote one very recent case which has come to me. In UP, this power, distribution companies, they have the different kind of understanding now in the law because of the advanced ruling authority rendered by the Rajasthan Advanced Ruling Authority, which I never read. I never read any advanced ruling authority because of the simple reason advanced ruling authority is not a precedence. It is not a judgment of the Supreme Court or a High Court. It is a marriage between two persons. So why I should take interest between the marriage of the two person? It is their private affairs. It is written. It is written in the law. It is binding on the parties, those who approach to the advanced ruling authority, not. But we as a citizens always feel like that, their marriage is good or not, it will affect my marriage. And we read so sincerely, that law. So what happened in UP, one of my clients, he approaches to that, you install a transformer or heavy, duty electricity line, and so that I can distribute to my tenant or the those who I'm going to sell my property. They said, if you ask us to install it at from us, we will charge 50. Otherwise, you can install yourself from your contractor. We will charge a supervision charge of 10%, 8%. Very well. But they said the GST we will charge on the entire amount of 50 crores. And they quoted the Rajasthan Advanced Ruling Authority. My client approaches to me. He said, some people give, if you want to trap somebody, so you have to trap a rat. And you have to give, So they said you can get input tax credit. We will give you the bill. You pay us that GST. You can take a credit. Their officer also believed that he will take a credit. Why we should fight it? But it became very difficult for them to take a credit. That's why they approaches to me, because their project is completed. After completion of project, you can't utilize it. Then I said, it is such a dangerous proposition. They are giving it to you. And all these officers of the DISCOM will go to jail because they are not supplying any goods or the services, but they are giving you the bill. Read section 132. If you are giving bill without supplying of goods or services, it is an offense. How they can, ask you to pay? Secondly, they are not supplying anything. Supply is made by the third party. They have charged GST. You paid it to them. You take the credit or not credit on that bill only. Then I said, now you give this opinion. If they will understand it, otherwise we will go to the court. Whether they want to go to the jail or something. And rather I asked them if they will give you the bill, how it will set off. Because the section 16 also says you have to pay within 6 months that bill. You will never pay. How you will take even credit otherwise also? Because the bill, it is a take bill, na? It is a notional entry only. How they will file GST return, I do not know who has given that kind of advice. Therefore, sometimes if such a situation arises, to my mind, as a professional, we have to use the different provision. Like they quoted section 15 2B. They said any amount which is used by him, that it will be added in the value. But I use the section 132, 122 to make my point so that they forget section 15 and save their own skill. So any case comes now, we have to go to the different facet also. Supreme say, no, I have the power this circle. Then you have the different circle, your power is limited to 10 lakhs. Now, where you want to go? Right? So you have to argue sometime in a different way. Then only the case is made out. If we think on those lines, with the superintendent teaching us, then their case will, spoil, somewhere. So these things. Now, A couple of more points I want to make observation about the audit and scrutiny. The question was asked. Very interesting. So section 61 is for the scrutiny. What happens? Section 61. It is written as probably ASMT 10 they have to give, and in that ASMT 10 they have to give the observation while during the course of the scrutiny. If any discrepancy found, they have to give us to us, and then we have to reply to that. And if thereafter the subsection 2 says, if they found my reply is not satisfactory, then they can issue me a show cause notice. That word is not satisfactory is very important. First thing, I am giving today an advice. If somebody will come to my office, I may charge 5 to 10 lakhs for the same very advice. And if you will use that advice, I am sure you will be benefited. But the only thing is that don't argue at the stage of the superintendent. Let me warn you, for your own benefit, not the benefit that you have to come to me for taking any advice. Because first, let the food be cooked, and then you should find out there is a fault or not. Without cooking, fully cooked food, you will find out the fault. Then they may recook the same thing. And that will go against your SSC. Let me tell you, even if my SSC has the worst case, I still believe I can win that case. And that should be the power of a professional for any profession. Because the professionals are being hired, not because of that they are professionals. If those things you can make a good things, then you are a good professional. So why the first thing I told you, that it said that if it is not satisfactory, they will never write it is not satisfactory. They will give ASMTP 10, you will reply in 11, and then a show cause notice will come. Nowhere you will find 99.200% cases your reply was not satisfactory. That means it was a satisfactory thing, that the show cause notice is on the wrong premises. Second thing is that, which is most important, ASMT 10 is issued by the another officer, show cause notice issued by the another officer. That is the newer things I am telling you. I am taking in central excise, service tax everywhere. I hardly lose any case. That's why the people ask me, how you can make out a case? I did not pay tax. I am saying, I did not pay service tax. Still, I said, I will win this case.
Sir, in Maharashtra State Department, there is no concept of the different authority. In Maharashtra State VAT Department, they don't have a concept of the different authority. So the person who issues the SMT, he issues the show cause notice. And in the reality, in each and every show cause notice, they write the one letter. It is not satisfactory. Without stating it. So what we are telling you now is that, so when you are written not so, you have to state a reason. So that's what it is a bad in law. In appeal, when we file appeal, immediately we write that not satisfactory is written. But you have not quoted the reason. And the supporting on what ground that he said not satisfactory. And when I am asked to give the difference between the reconciliation between R1 and 3D, then first he has to tell me the figure which are the R1.
Very good. That's what I'm saying. First he has to give me.
And in 3D, I have not recently universal details because that was never asked. And you look at the 2019 amendment, the GSTR3 was replaced by retrospective amendment.
Yes.
So at the time of filing of the 3D, I want to declare this.
Yes.
So then we are speaking of the notice itself for that period, 1718 till the date of retrospective amendment. I mean, in VAT department, they have been taught by the nation and other trainer that whenever you write a show cause notice, then you write that first line. Your reply is not found satisfactory.
It's a printed, sir.
Okay. Then
The reason is also very important.
yes, merely writing not satisfactory is not enough. Not satisfactory on what basis? Otherwise, it is a without application of mind.
Yes.
Cyclostyle. In fact, there are n number of judgment I have found. Once they give any, like now in Jharkhand High Court has given a number of judgment. NSK is something I've written here. And that they said, if your, show cause notice is deemed to be without application of mind, if you give it on a pre-printed forms, you have to, score out what is not applicable. You can't give a pre-printed forms. And there are Supreme Court decisions also on this count. So therefore, I fully agree with you. If they have been taught, you write first line, not satisfactory, that will not serve the purpose. They have to write why not satisfactory, and that must be reflected from their application of mind, this was my reason and this was their reply, and that's why it is not. Merely writing one word will not be sufficient. Second, you have answered so far as State Department is concerned, there is no different rank. But so far as central, there is a different rank is there. My answer, at least for the central, you assume is a different officers. Then how he came to know what was my view? Because I have given the SMT 10, reply came to me, unless I find something and report it to him, which he has to annex with his so-called notice. He can't write not satisfactory, because how the view taken by me can be substituted by his view. That is also important. Now, another question Mr. Mittal asked me before the conference start. In the state law generally, because if the section 5.3, if you read 5.3, then the power can be delegated. And now the two questions arises. One, the power definitely can be delegated. My view is that when the power is, particular power has been given under the statute, that can be delegated. What was his question? Like under the section 67.2, the power is with the joint commissioner. Joint commissioner delegated to the deputy commissioner. Deputy commissioner form an opinion whether that can be formed or not. There are two things I will quote here, judicial pronouncement. One is the Radhakrishnan judgment came from the Supreme Court in bank attachment. That issue not argued, but was they presumed that it can be delegated in one way. But while interpreting section 107, they said it is a delegated power where the appeal can be filed only against the commissioner order. Therefore, it is a joint commissioner order. No appeal can be filed, only the writ petition can be filed. In most of the state cases, you take that Supreme Court decision, appeal is illegal. Because as per section 107, when the order of the commissioner is the adjudicating authority, only that order can be in appeal. And in state, commissioner never passes any order. Order is passed by the junior rank officer only. That means no appeal will ever lies under the GST law. You quote that. Sometimes you want to take a benefit, like the people say alternate remedy. I have filed one writ petition against the huge demand in Calcutta High Court. My client every day asks, I have no money to deposit it. This demand is mostly on the electricity and the bank guarantee, which issue you may be facing. So from where he will pay that money? Then I said, now I have a judgment. Writ petition is maintainable because the state assistant commissioner is not the adjudicating authority where the appeal can lie. Now the second thing is that my view is that once the section prescribed a particular designation, it cannot be substituted with the other officers. Under rule 5.3, general administrative power, he can do it, but the law prescribed. The third is the Gujarat High Court judgment in some Dajija case, or full name I could not remember, where the arrest of a person was made under GST. And when the court asked to produce all notification, etc., they found that there is no such notification exists. There is no delegation. They write delegation something. Therefore, we have to ask those things. If some notice comes, you ask under which law you have been authorized, which is the notification. If they don't provide, that will carry on. Because if you are not asking, later on they produce, then it is merely on your presumptions that we can take it. Because the whole idea is the law should have been simple, ease of doing business, which to my mind does not exist in the law. And lastly, I can discuss about it, role of a chartered accountant, whether he can be interrogated or like this and that. My mind, there are, another slides I have, which sometime later we can debate and discuss on that. So far as your code of conduct is there, which you read it carefully, there are judgment to that effect. When some information during the course of your employment, you get it from your client, without the written consent of your client, you disclose it, then it is a serious professional misconduct and you can be debarred from your practice also. Therefore, you have some kind of protection under the law. You should not disclose any of the information which you have got it during the course of your employment. Second thing is that if you give an opinion, whether the officer can ask you about your legal point of view, legally speaking, he has no power. But I came to know last year or sometime back, the three of the officers who were earlier working in the department in the highest position, one has become even, in fact, the C-state member very recently also. They, after retirement or voluntary retirement, they become an advocate, and they were the member of the bar also. they give an opinion to one particular company. And the superintendent issue all summons to all the three persons. Why you have given that opinion? I can give my opinion whether you agree or not. If my client follow my opinion, that does not mean the officer has the power to summon me. That I am very, in fact, the many advocates were being summoned in 2017, those who approaches to me. I said, you will never go. I will hang them. In fact, one of the advocate case I am, reading now, say 100 crore rupees demand has been demanded from an advocate. Despite knowing that the advocates on the reverse charge, they said it is not a legal service. That advocate every day appeared before the, almost every judge know that advocates, he's very senior, and his turnover is huge. He's generally rendering service to the foreign companies. So they can change the color of your service. In fact, their own document said it is a, like the officer is a written reverse charge, like, but he is the same said, no, this is not a legal service for the same very person, for the same very period. Therefore, the officers doing these jobs only because probably that I never seen government of India would have taken a serious action against those officers, those who are doing misadventures and defaming the name of the government of India. This good law. Therefore, the chartered accountant has the very much defense, not only in the GST law, in other law also. Now the question arises, like some of the chartered accountant has been, directly or indirectly, might be, yes. There has to be allegations that they were the part and partial of it, and they have taken the benefit of it. Beneficiary, section 132, which was amended, it's a beneficiary. Like the recent Gurgaon case, if you take, while granting the bail, the High Court has written, the chartered accountant not the beneficiary of this transaction at all. If they are not the beneficiary, how the 132 can be invoked against those chartered accountant? Therefore, we have to take, the arguments at the right time, at the right place, and we have to stand by our, stand. Merely because someone has been issued, that does not mean the summon is valid. If we challenge it, he will go to the court, we will challenge it. Like another chartered accountant did not appear, and we challenge that summon. Challenge even is pending in the High Court. In the meantime, the department filed a case, in the magistrate court. And the magistrate court same stand. They said, what is the harm you give that information? Question is not the harm or not harm. Question is that of the power of that officers, whether he has the power it or not. Therefore, these questions always can be taken up. If you want, I can go on and or you want the certain questions.
Any questions?
There is one question and some people have raised their hand. So
Yes, you give opportunity to them.
So this was in relation to when you had said that even if you are able to prove that a search is illegal, but still the documents which they were obtained during the search is still valid and they can be used against you.
Yeah, there are difference of opinion now, because the one case was Puranmal case long back decided by the Supreme Court. That time provision was different. If the search is illegal, then everything become illegal also. But the document, even if they use it, that will be the second case will be taken up. Because once you challenge, because whenever you challenge the search, in most of the cases which has comes to me, they comes to challenge it because they feel harassed. Every party wants, even if I have done something wrong, let the so-called notice be issued. It will be adjudicated. They said they are being interrogating us for late hours. They are asking us to forcefully deposit that amount. That at least go.
I'll allow Mr. Girish to speak. I'll allow you to talk. You can ask your question. Girish? Yeah, you can unmute yourself.
You
Yeah,
can ask a
in the
question.
meantime,
16/4/17.
yeah. Hello, yeah. So in the meantime, the power to conduct a search is at a business place. And if we look at the other places which they have mentioned in section 67, I'll just read that section 67(2). It says he may authorize in writing any other officer of the central tax to inspect any place of business of the taxable person
Mhm.
or persons engaged in the business of transporting the goods
Mhm.
or the owner of the operator of the warehouse of the goods or any other place. So can this any other place be considered as the place of residence of the director?
To my mind, it could be any other place, means any place. But the thing is that he, before going there, he must have some material in his hand. Either something was secreted there, which was necessary in the proceeding pending. If it is not there, then the search is not valid. So generally, they go there to threat it and to later on to recover it. If you read the judgment of the in the Seth case, which I have referred in my presentation, very old judgments. If you challenge those proceedings, then they have to show it before the court that they had some information prior to that. Otherwise, such is illegal. Like in section 147, 48, you said if there has to be some materials, then they can reopen my assessment. And that material has to be beforehand, not after that. Therefore, that you can challenge it. They will go there, but you have to challenge it. As soon as you will challenge it, then they will not proceed further. That is my, whatever case I take up, then it becomes like recently I visited Gujarat High Court. After 3 years, the case came up. The just first question asked me, we did not grant you the stay, we merely issued the notice. After the search and summon, what happened? I said, nothing. Because their motive was to take bribe. We did not pay the bribe, and now it is in the High Court glare. Nothing happened. If there was actually something, they should have done something. The other place could be, but you can challenge definitely. Yeah. Yes, please.
Mr. Subramaniam, I think you can speak.
Hello,
Yes, you can be a bit louder.
hello, I'm audible, sir.
Yes.
Hello, sir, I have two questions, sir. One is in respect of a cash seizure. Say what happened during the investigation, the officer seized the cash. So whether can we say that the entire search is illegal one, or can I ask, there are certain liability, can I ask the officer to adjust this cash towards a liability? This is my first question, sir.
He has asked that when the officer sees the tax, so cash. So can they adjust that? Can you ask the officers to adjust that against the tax liability?
That's the second question. The first question was they have seized the cash. Can the entire search proceeding become illegal because of the seizure of cash?
No, that cash can be illegal, but the other proceeding, may be valid. That depend upon how you argue, whatever your prayer is there. Second thing, so far adjustment against the liability is concerned, that has to be crystallized. That will be crystallized once a so-called notice will be issued. Unless a so-called notice is issued, how it can be? The two judgment I have quoted here of Delhi High Court prior to GST, which such practice was there in the VAT department and the central excise department. Delhi High Court came down heavily on those cases. They said how you can get that power without a so-called notice, you say that much evasion of tax. And they said refer the matter to the Central Vigilance Commission to make a guideline, because they said that there could be two situations. Evasion was 500 crores, you took a bribe and make it 5 crores. But there was no bribe was paid, you make it as a evasion of case, there was no evasion at all. So therefore, the law is laid down that like Kassab was not hanged very next day, we all seen he was killing people's hair. But the trial was given and a lot of money was spent. Therefore, here you see the winning rate of this department is maybe 5%, maybe 10% only. 90% case they lost everything. How you can believe on their allegation? Their allegation will always prove to be false. And that is true without any evidence. Or you won't believe, day before yesterday, I was in Puri. My office called me, an urgent meeting, they want to have online, we had an urgent meeting. One person get a penalty notice of 80 crores. And this, DRC 01A. And I said, you just give 2-line reply. This is totally vague. I don't agree. And this is without any evidence. Just they said, something you pay penalty. At least some evidence has to be there. How this case can sustain. And I said, don't argue with them too much. Don't give your mind to them. Lest they issue a proper so-called notice, and proper so-called notice generally come with a copy paste of the same things. We get, yes, next.
Is there any online? Then
There are, but you can take.
Sir, so what is the right point of time to challenge the search? Now, what is
Immediately.
but we don't have a search warrant copy.
You need not to have it.
Okay,
That only the court will have it.
okay, fine. And then another issue that what we find practically in most of the search take place at the office hour, but it lasts till 2 o'clock, 4 o'clock midnight. Now, I had discussed with one of the lawyer who is doing human rights. He could not understand because he was not in practice of the taxes. He never understood that what I am telling you. Now, my another point is that we find when we go and challenge the search warrant, the court never imposed the cost to the person concerned. Now, my point is that because I am very much annoyed with this kind of the practice, I had discussed personally with the state commissioner many times. That look at your office, that there are so many abuse of the power instead, but you are not taking any action. You say we recover the money, we want the money, what do I do? I mean, I'm not going,
The second question, nobody can answer because what the Justice Swinton has answered, they said there is an abuse of power. That's why, which I forget to tell you, if a summon is issued, there is a mandatory now, the Supreme Court decisions, they must have a CCTV camera and record a statement only under the CCTV camera. So even if your client want to go, first you write a letter, do you have installed a CCTV camera or record a statement? And most of the officer will say, don't call him again. So then you also make, like this, because if the court do not punish it, the court sometimes say, Mr. Mittal, client is very happy. You should be very happy. Leave it here. Many cases I have not discussed here. These always happen.
My second question is that it's not out of under the taxation law, but under the human right. Can we ask and invoke the human right commission to this matter?
But it would be very difficult, sometimes to prove all these allegations. These happens. You remember one Gujarat High Court? Yes, where not the party wala, before that the another bench was there. And I think Justice Harsha was there, and see that many people staying in the house, ladies were there, and stay continued. And then ultimately petitioner said, I don't want any action because he's also afraid for post. Similar things has happened, I think, in Telangana also, where some slap, some physical attack was also done. Then the court said we don't want to go in these facts because whether attack was done or not, how one will prove it is required evidence only. So sometimes, purpose of going to the court is that the further harassment do not take place, and you get what you want to get. Because in our country, you should satisfy when you have no chance to get anything.
And the last thing for the general public, because we chartered accountant, most of our crowd is that we take it very lightly. The something what happens at the time of the search many times, and when we look at the assessment and appeal time, then we find that these things should have been done at the earliest point of time. The one common thing is that what we are doing is retraction of the statement.
Yes, retraction.
Please throw the light on the retraction of the statement.
Okay, there are 2-3 things. Sometimes, suppose the case has come to me today, after 2 years. So whether retraction or no retraction, it doesn't affect it because retraction has to be at the earliest time, and it should have been not by the professional, by the assessee himself. And retraction. But you must understand, only on the basis of the statement, no tax liability would be faster, even though sometimes the statement is treated as evidence. Another judgments you must know. Statement given at that particular point of time is not a statement will be taken as a gospel truth. At the time of adjudication, that statement must be recorded again. If you read the many judgment, particularly Delhi High Court and Allahabad High Court and then Punjab and Haryana High Court, the statement has to be recorded. First, it should be admitted as an evidence by the adjudicating authority. Then you can ask the cross-examination of those also. So statement is not enough. Sometimes we believe that, like in one of my case, earliest when we joined the legal profession in 2005, 2006, I filed a case in Delhi High Court. The bench was going through the paper and they found that your director has admitted that this examination is not applicable. I said, very well, if you accept that kind of statement, my directors will always say, I'm not liable to pay tax. Then what you will decide? This is a question of law. No question could be asked. And then ultimately that case become GD builder case, which is very famous case up to Supreme Court. So then you have to be confident about, what you are talking about. Statement of a person, Gujarat High Court said if a statement is recorded at midnight during the course of search, it has to be under question. It can never be a trivial statement at all. Therefore, merely statement has been given by anyone against you. Like recently one case has come, though it has not been carried forward with me, it will come maybe later on. So cause notice has come. Along with that, the 40 statement were there. I went through the statement. I said, this statement appears to be of same person. How there could be 40? This is a statement of not same person. You read every statement of a different person, but is written down by the same person. Sign is only different. I said, you give me the case, or you file a criminal case against these officers. They will be behind bar for entire life. You are creating a false evidence. You read IPC. Any public servant created a false evidence is a serious offense in the law. And that would be behind the bar. And I don't think so. Section 197 will apply. CRPC, you need a government approval. Government approval when you are doing during the course of your job. If you are, that is not your job. If somebody is stealing, something, that is not during the course of it. Therefore, you have to take a different. That's why if you understand thinking, a case comes, like I told you, the search in Mumbai, the different signature, you have to devote more and more time and you have to turn to the different case. Every client asks me, what benefits we will get? We will go to the court. What shall be your prayer? Once that thing happens, you will understand. I'm not arguing the case before you. So once you will give a consent, then more mind will work. You will read the document again and again. Something happened. I can assure you that once we will file a case, I'm sure your harassment will not happen. That I am very sure with my experience of last 20 years. This department only know the tit for tat. Yes, other things, if we can take the question.
So Mr. Girish had asked that you had mentioned about a fake invoice case and corresponding sales are also to be removed.
Yes.
But department in Maharashtra is asking to reverse the ITC with interest where they had cancelled GST number suo moto. What we discussed initially, the retrospective cancellation.
Yes, there are two things. First thing is that department allegation is only there that you have to reverse the input tax credit. Once case is made out, you have to take the same very stand. I have paid the taxes, they have not denied it. Secondly, if my purchase is bogus, then why you have not made out a case against them? You collected the tax from them. Because if he has paid the tax, he has filed a return, which I will tell you, they will not produce those evidence. You have to file. In fact, let me tell you newer things. A summon not only can be issued by the officer at his own instance. Summon you can also ask. The summon should be issued at your instance because you also want to produce your witness. Every so-called not say if you want to produce any evidence, yes, this is the person. I want to call him in the witness box or for my evidence. Let his return, because from him I have purchased it. Let his return be filed here. And if his return is filed where the tax has been paid, then my, of course, purchase become original. This circular is saying you should not collect the tax from him. If there is no supply, he is liable for only penalty. But you are saying to me, his supply is bogus, but you have collected the tax from him. So that evidence you have to produce. And you can make this so-called notice as a help for those officers. Let me tell you, you can ask those officers to be in the court or to the in the adjudicating authority because he has investigated. He issued so-called notice. Let me take the example of center. The state may be saying. Then he is making an allegation. He has investigated. He should come. Whether he has given any such report, your question should be very, it comes with an experience. Like one point of time, I charged 5 lakh rupees to make one RTA application. An RTA application costs you 10 rupees only. The question was such a that because of that, I won the case of 66 crores. Therefore, what question should be asked? Don't ask the question whether fake invoice or not. You ask, did you prepare any inquiry report after investigation? He said no. If he has not prepared, how he came to know? Is he a god? That means his so-called notice is bogus. And let me tell you, 99% case, nothing for his own record. No inquiry report is on record. Therefore, these things I am discussing. Generally, no advocate will discuss it because he is revealing his whole argument. But, but it is depending upon how you can take it. Merely knowing the law is not enough. How you implement it, that is very important, how confident you are. Therefore, to answer to his question, reversing the credit is an allegation. You have to defend it with all such kind of things. You can discuss and debate more about it. And second point is also asked about the
So when they are specific.
about the registration cancellation. That has become, most abused power. I have challenged before Delhi High Court and Gujarat High Court all those provisions. Retrospective cancellation. Can you have the power under the law? Second thing, without granting even an opportunity, they are suspending your registration. Thirdly, the rule 21 or something is there, or 121. What is the rule? And corresponding section, you read the 29. That is not gelling with each other. You read, section says, if you have a reason to believe your registration is liable to cancellation something. And he said, registration shall be cancelled something. I have made out, all my arguments. The rule cannot go beyond the section. And to my mind, the rule has gone beyond the section. So these are a long talk discussion. If you would have talked only for cancellation and revocation, probably 1 hour I could have devoted on that also. This power is abused. Only thing I can say, you take the 6th High Court decision, I carried it with me in Delhi High Court. Every High Court saying is that why you are cancelling registration? What benefit you will get? We will carry on the business, you will pay. Secondly, one of the things that came in my mind, this Narendra Modi government came on this black money. Have you ever heard any person who evaded income tax's PAN number is cancelled? Not even a single person in this world. So how you can cancel? Secondly, cancelling GST registration means you are cancelling oxygen pipeline of a person. He will die because he cannot carry on the business. It is not a one contract. Suppose I have an institute audit, you cancel that audit, I can do my other business. But GST cancellation means I cannot do anything in my life. And that too without any finding. Merely a superintendent will cancel it. Thirdly, on the basis of that, I did not find him. Vijay Malla, you did not find. Because of that, I travel in his flight, you cancel my registration. How you can do it? Therefore, the court is taking the view against the department. I did not find even a single case where the view is in favor of the department. So that we have to bear the brunt because the society is changing. Or either you have to make very strong representation before the ministry with an evidence. Like I make one complaint to the Nirmala Sitharaman. I used to make many complaints. This is one of the things I am citing. I am not afraid about my practice, whether go down or not, because I don't want to be friend with the corrupt people. That is my way of life. The few, company came to me and they came jointly because there was a similar case, but they all were issued summons by the same very officers. Someone were carrying the same DIN number. I said, how it is be possible? I immediately wrote a letter to the Nirmala Sitharaman. Your intention was to have DIN, to remove corruptions, to bring transparency. If the same DIN number is there, better to have no DIN. Then the entire thing, so from 13th September 2021, website was changed. Now DIN verification will show whether the search, inspection, whether GST, custom, etc. Earlier these things was not there at all. And rather more transparency should come to whom it was issued, whether the same DIN is being used by multiple persons. So if I ask every client, have you verified DIN? You must give it to me. Sometimes you find that DIN is generated subsequent to the everything was done. Like one thing in Arvind Goel case, we argued that they said in the Panchnama, the search authorization of the 3rd, April or something. Whereas in the affidavit file, they said that we have carried out the search on the basis of the 4th April letter came from the Bhopal Commissioner. If the letter came on Bhopal Commissioner on 4th, on the basis that how the authorization came on 3rd. These things will come, you minutely examine. I have a habit from my childhood to examine to that extent. Because wo apne aap nahi pata chalega. If you see from the suspect angles, like, department have suspected every transaction despite transparency. But to my mind, the GST has no benefit if you investigate everybody. Then what is the benefit of digital India?
Whether this is a case when recipient supplier both are in 2 different states, So whether a Hyderabad party can be summoned by state GST authority where the supplier is from Maharashtra for taking statements, or can it be, or can we then request them to transfer the findings to the Hyderabad office?
Yes, there are certain, the High Court rules, because if you see the section 70, the CPC is also applicable. I am told under the CPC, sometimes the territorial limit is fixed for 50 kilometers or so. Certain High Court rules or somewhere else, I did not find in the CPC itself. Then you can take that plea. To my mind, if any offense is happened here, like say suppose a murder has been committed here, and then if they find a lead, I'm in Guwahati, even they can call me, for that, and they can bring me from there also to record a statement, so far as the case is concerned. But whether they can extend their jurisdiction to examine it, and secondly, you must see whether you are calling me as a witness or calling me as a accused. That also you can raise a point. Because in criminal jurisprudence, you have to write, you are my witness or you are accused. Here they are asking everybody to come. There is a evasion, and sometimes they don't write evasion against whom. You must ask them. So there could be, such things, cannot be straightforward answered. You have to challenge those things before the same very officers. Because sometimes there is no evidence at all, just to harass somebody. Because the GST network has become like such a widespread. They said one case is made out in Delhi, one in Karnataka, one in Guwahati for the same very transaction. I fail to understand how this can happen. The practically one discuss, only then one can understand what steps should be taken.
Yeah, we are done with the questions on that.
Sir, one last question before we conclude. Many times when department people come, they also insist, to, as you rightly mentioned, they can seize the laptop, which is a personal asset, not necessarily a business thing, personal mobile. Sometimes they also, insist they give us your email ID, show us your emails. To what extent that practice is
First
correct?
thing you ask, give us in writing mandate everything. They don't give in many things in writing. Secondly, so far as professional is concerned, under Indian Evidence Act, to my mind, that is applicable to the chartered accountant as per the various judgment also. The certain confidential, things are there between the assessee and the professional, that is fully protected. Like in Delhi High Court, one of the advocate wents was the police want to investigate all these things. He said, I can't reveal those data which is of my clients. That the court passes an order. You can examine it, but you will not take the data which is of his client privilege, attorney privilege, those things. And as soon as this order will come, the officer will not touch it, because he want to, sometime one of my client told me, he has seen some my conversation with, one of my girlfriend, and he said, "Ki, main aapki wife ko bataunga." मैंने कहा कि, you immediately filed a complaint. That is not the purpose of, investigation of GST. That means he's blackmailing you. So you can, immediately take steps. This is, the data preserving as a professionals, and you will not use that data, and you will not touch that data at all. Because he can't inject, in my privacy or my professional life. Otherwise, no profession. In fact, you read the judgment, which I quoted in another slide. They said, if the professional will start revealing, these information, it is not because of the misconduct only. Then the society will lose the trust on that person. Therefore, we can't permit you to do it. Therefore, otherwise, who will trust on a chartered accountant? I am revealing everything to him, he will disclose it. Therefore, that things you will take it. But whether it contains incriminating material or not, that only investigation can tell. So what we can protect it in my personal data, which has nothing to do with any investigation you are carrying out. One more things. In fact, the investigation in GST or that matter on service tax and excise duty, you will find one newer things which happen only in this law. The investigation for future period, along with the past, like they will carry out the search, let's say in 2018. Now they will issue a summon who are that search in 2023, bring your data from 2017 to 2023. Is it a continuing search? Is it a continuing investigation? It cannot. Law does not permit. So therefore, we can take all this stand. Then only you will find it. Because Only thing is that the department officer will not mend their way. If you want to find a solution, you have to take this stand. Wherever necessary, you go in appellate authority or before the court, then only you will get benefit. Or sometimes you make a complaint also against those officers.
So I think it was a wonderful session. Just to give you a parallel example, it's like Rohit Sharma's triple century in T20. So I request Chirag to give a vote of thanks. Thank you.